Before this hearing even begins, the courtroom is already divided. Prosecutors describe an explosive family dispute involving an alleged attempt to strike a sister with a vehicle and extensive property damage. The defense pushes back just as forcefully, arguing that the allegations are old, the timing of the charges raises serious questions, and the requested bond is far too high. As both sides prepare to make their case, one decision from the judge will determine whether the defendant goes home, or remains behind bars while the case moves forward. Stay with us, because this bond hearing quickly turns into a tense legal showdown.
Bond from the people.
Thanks, Judge. A matter that allegedly took place about 11 months ago. Here, Judge, the defendant allegedly gets into a fight with her sister. She had just picked her up from work, allegedly. They fight in the car. The defendant allegedly stops at a gas station, drops the sister off, tells the sister to get out. Sister gets out, and then allegedly, Judge, the defendant proceeds to try to run, or at least hit, her sister twice. Once being unsuccessful, the second time attempting again, unsuccessfully. Your Honor, the defendant then, subsequent to this incident, proceeds to go to her sister's home, busts out all of the vehicle's windows of her vehicle at her house, all of the house windows, a glass table, and then she takes her sister's license plate. Now, Judge, I realize the fact this is an incident that took place in June of last year. However, the people would like to know that this defendant is currently going through an additional matter for an AWIM, as well as a domestic violence. The people, as a result of the alleged facts in this instance, as well as the fact that this defendant is also going through a different matter, highly assaultive, we would be asking for a $50,000.
At this point, the defense shifts the focus away from the allegations themselves and toward the legal process. Counsel argues that the events allegedly happened nearly a year earlier, yet the warrant wasn't issued until much later. According to the defense, if the defendant truly posed an immediate danger, why did the case remain inactive for so long? Prosecutors, however, maintain that the seriousness of the alleged conduct, including 2 reported attempts to hit the complainant with a vehicle and significant property damage, justifies a substantial bond. Bond hearings aren't about deciding guilt or innocence, they're about balancing community safety, the seriousness of the allegations, and the likelihood that the defendant will return to court. What do you think? Should the delay affect the bond decision, or should the alleged conduct carry the most weight?
Fact, to charge her on this case. The file sat there for a year and they did nothing. So it completely undercuts the people's argument that she would be a dangerous or a threat to anyone in society. With regard to the new charge, Judge, first of all, this was not an AWIM. It was an assault with intent to do great bodily harm charge with a domestic violence that was dismissed today, that I represented her on, and I waived her appearance because she got picked up on the warrant for which she's currently before Your Honor. My plan all along, I did not know that this old charge was pending. Again, the warrant wasn't signed off until after she was arrested on the, quote, new charge, which was dismissed today. So all of that to say, Judge, any cash bond is clearly excessive in this case, let alone $50,000. We are asking for a personal. She is a mother. She was let go of her job as a result of this arrest. I just think the people's characterization and request is patently unreasonable and excessive, and I ask for a personal.
Your Honor, just with all due respect, we've been on the record for 3 hours now. I did mention the fact that there was an examination. I didn't know, the final results of that because we have been here. However, with this specific charge, I don't know if counsel has talked about any mischaracterizations of what allegedly occurred. We end up having a complainant here who ended up almost getting hit allegedly by a motor vehicle twice. And we had windows in her car, in her house, a glass table, all broken as a result of what the defendant did. Now, ironically, we didn't have any arguments regarding that characterization or lack thereof.
And
all right.
if I may briefly respond.
Go ahead.
Yeah, it's not ironic, Your Honor. It's because it's one factor that this court considers is the seriousness of the offense, right? And the seriousness of the offense is not that serious. Why? Because this is a 2.5-year felony for which her guidelines would be probation. It would be excessive to keep her in custody on these allegations, which the people did not, in fact, file for almost a year. And so it's not a matter of whether or not my client is alleged, again, to have tried to hit somebody with a car, but we're looking at the nature of the offense, the charge with which she is actually charged with. And Judge, keeping her in jail pending bond when realistically it's probably unlikely that this case is going anywhere. We don't know her sister wants to prosecute. So I think a cash bond would be completely unreasonable, and I'm asking for a personal.
Okay. The matters that were dismissed today, was that because the complainant failed to appear?
Yes, not only did he fail to appear, but he called both me and the prosecutor on multiple occasions, indicating that he did not wish to press charges and wanted her out of custody.
Okay. All right, ma'am, these are serious allegations.
Now comes the most critical moment of the hearing. The judge acknowledges that the allegations date back approximately a year, but emphasizes that the investigative report describes conduct the court considers extremely serious. Because of those allegations, the judge imposes strict no-contact conditions and ultimately sets bond at $10,000 with a 10% provision. The defense immediately argues that the amount is effectively unaffordable and points out that the underlying charge could ultimately result in probation rather than jail time if convicted. The court, however, explains that protecting the alleged victim remains the primary concern. This exchange highlights one of the most difficult balancing acts in criminal court, weighing public safety against a defendant's ability to secure release before trial.
Okay. This matter does stem back from approximately a year ago. However, the court again feels that these matters are very, very serious. Court is going to set your bond in the amount of $10,000, 10%. You have a probable cause date of June 7th, preliminary exam date of June 12th, 2023, 8:30 a.m., 36th District Court in front of Judge Giles. Counsel, is this an affordable bond for her?
No, it is not, Judge. I am appointed counsel with the Neighborhood Defender Service.
Okay, she will have a bond redetermination hearing on this Friday, June 2nd, 9:00 a.m., 36th District Court in front of Chief Judge McConaughey.
Your Honor, is there any way I can convince the court to reconsider? $1,000 for her is tantamount to a remand. I understand.
Well, that's why she will have a bond redetermination hearing in 2 days. So,
and Judge, she's looking at probation on this case, so she's not going to likely do any time as a result, even if the prosecutor is successful at conviction, which again, I don't think they are. So she's effectively sitting in jail on a charge that doesn't even warrant jail time.
Well, the court sees it a little bit differently. The court has to take into consideration the information in the investigator's report as well. And so for that reason, that is the bond that will be set. But there will be a bond redetermination hearing on June 2nd at 9:00 a.m.
And just so Judge, just so I'm clear, the court is intentionally setting an unaffordable bond because of the allegations
that is
alone.
Correct.
In the end, the judge declines to lower the bond despite repeated objections from the defense. While acknowledging that several legal factors were considered, the court explains that the alleged danger to the complainant ultimately carried the greatest weight in the decision. The defendant is informed that a bond redetermination hearing will take place in just a few days, providing another opportunity for the issue to be reviewed. It's important to remember that this hearing focused only on pretrial release conditions, not on determining guilt or innocence, which can only happen later through the legal process. If you found this courtroom hearing interesting, let us know your thoughts in the comments. Do you believe the judge struck the right balance, or should the bond have been lower? Don't forget to like the video, subscribe to the channel, and turn on notifications for more real courtroom breakdowns and legal analysis.